This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. The unprecedented coverage the Simpson case has received has in effect put the criminal justice system on display in every home across America. Today we're going to look at the relationship between the defendant and his trial attorney, the defense attorney, whose skill and manner in the courtroom may very well determine the accused's future. Our guests are Benjamin Brofman, a criminal defense attorney, and Gregory O'Connell. Gregory is former Deputy Chief of Racketeering of the United States Attorney's Office, Eastern District. Gregory is now in private practice and now is a defense attorney for clients who are accused of crimes. Hello, Greg. Hello, Ben.
Hi.
Ben, give us an idea. Guy comes to you, a woman comes to you, and all of a sudden they're indicted and terrible crimes. What's the first thing you ask them?
Well, there isn't the first thing you ask every client because most cases are different. Generally, the first thing you do not ask is whether or not they have committed the crime. That's a difficult question to ask a person who's essentially a stranger. You have to warm up in the relationship. And sometimes, quite frankly, you never want to know the answer to that question. Sometimes, as a defense lawyer, you can figure it out based on the evidence that you see or the evidence that the government makes available to you. But sometimes you never really have that specific conversation.
You never want to know whether your client is guilty or innocent?
I didn't say never. I said you do not always want to know. There are some cases where it is easier for you to handle the defense if your client has never told you what has happened or has essentially denied his or her involvement in the crime, and then you have an obligation to accept that. You have also an obligation ethically not to put on a defense that you believe requires the fabrication of evidence or allowing people to lie.
All right, I come into your office, I'm distraught, I've just been arrested, I'm out on bail, legal aid got me out, and I want to just blurt out the whole story to you. What do you say to me?
Sometimes that happens, and sometimes you listen, and sometimes it's very helpful, because sometimes even in an admission of wrongdoing, there are nevertheless the kernels of a defense, because sometimes whether you did a crime or not is not what is at issue. Sometimes it is the state of mind of the accused. Not every case is an open and shut case as to whether what you did, whether it was wrong or not. Sometimes whether you intended to commit a crime is more important as to whether what the facts actually are.
Greg, how do you see that? As client comes to you, do you want to know if they're guilty or innocent?
I think it turns on the case. In certain complex federal cases, for example, involving an array of financial transactions that you couldn't possibly discern on your own without the client's assistance, I think the client's going to have to walk you through, or you'd need the assistance of someone close to the client with knowledge, or an investigator who would help you find a path through all of it. But there are cases where you're going to rely upon the client's assistance in just coming to learn and understand what the whole case is about.
Greg, if you know your client is responsible, your client did it, do you handle the case any differently than if you knew he didn't do it?
Oh, I don't. I think, depending upon how the case is postured, perhaps that could come into play in an investigative stage, where you had a clear-cut understanding of a client's innocence and a wherewithal to prove it, and you were professionally satisfied that you could persuade authorities with the available proof to stop the advent of an arrest and a prosecution, then I'd say, yes, that's possibly correct. On the other hand, in an indicted case, I don't think that it should matter at all to a defense attorney whether his client is guilty or innocent. What you're out to do is to vindicate that client's rights, to look out for that client and to get the best possible result for him, and to ensure that he gets fair treatment and make sure that there is no overreaching on the part of the government or the people in a case in which he's being prosecuted, and just give him full assurance that he gets the best possible and fairest treatment under the law.
Ben, what's the defense attorney's obligation? Let's assume you know your client is guilty and you're representing your client to the best of your ability, and your client all of a sudden wants to take the stand. He takes the stand and goes, I wasn't there. I was at the McDonald's down the block. I had nothing to do with it. And you know it's not true.
Well, there are very hairy technical answers and questions that arise in representation of criminal defendants, and there is no concrete answer that applies across the board. As a matter of practical ruling, however, in a case like that, if a defendant insists on taking the witness stand and give what you understand will be perjurious testimony, you have an ethical obligation not to assist the person in the performance of that fraud on the court, but you don't have the right to stop them from taking the witness stand, and you don't have the ability to stop the person from taking the witness stand. And what generally happens in a case like that, in those rare instances when that problem arises, and I'll get to that in a moment, what happens is the defendant takes the witness stand. What I would do in a situation like that is I would make a record outside the presence of the jury that I have advised the defendant not to take the witness stand, that I don't believe it's in his best interest to take the witness stand, that given the substance of the testimony he or she intends to offer, I am not going to assist the witness, but I'm not going to do it in a blatant fashion so that this decision would be discernible to the trier of fact. And essentially what you would be permitted to do ethically is call the defendant to the witness stand, guide him through his background, and then say, do you have a statement you'd like to give the jury about the events in question, and sit down. You do not have the right in what is, in your mind, perjurious testimony to do a Q&A that actively assists the defendant.
Ben, are there certain crimes you just could not represent anybody for, or will you represent anyone as long as they retain your firm?
No, I've made decisions in the past. I have sent away substantial amounts of business each year in cases where clients have an inclination that they're going to be able to compromise either my ethical obligations or my own integrity. And when you practice criminal law, you understand that generally, as a general proposition, most people don't get indicted because they've been picked out of the yellow pages. There is some kernel of truth in some of the allegations, and some of the people I meet are wonderful people wrongly accused, and many of the people I meet are not good people who happen to need a criminal defense lawyer, and I have to be very careful not to allow those people to try and compromise me. So there are cases I send away. I will also tell you there would be cases that I would send away as a matter of principle, not because those people are not entitled to a defense, but because, knowing myself, I want to make sure that the crime he or she has committed is not so personally reprehensible that I would be less than my best. For example, I probably, based on my family background, would not represent a terrorist who went in and blew up a bus of Jewish school children because I have an Orthodox background, and it would keep me from doing my best. That doesn't mean I don't want that person to have the best representation available. I would just like to pass on that type of a case.
Greg, now you were deputy chief of racketeering. First of all, what is racketeering? What are we talking about?
That's the focus of the racketeering sections in the U.S. Attorney's offices in New York. Is on organized crime, mainly traditional organized crime, the 5 La Cosa Nostra families.
Now, of course, I heard that the mafia doesn't exist.
Well, that's why Greg left the office. It's over.
It's just about over. Now, rumors to that effect, I think, have been
greatly over-exaggerated.
I would say so. There's some apt paraphrasing of Mark Twain.
But Greg, once you put, let's assume, a leader of the mafia away, doesn't somebody just come up from the ranks and fill that shoes?
Well, someone will come up from the ranks. The shoes will be filled, but perhaps with somebody of lesser quality than the person they're replacing. I think what we saw over the years with the waves of prosecutions of high-ranking organized crime figures in the New York metropolitan area was that there was a real personnel quality control problem that these crime families were experiencing, particularly the Colombo crime families, Lucchese crime family, and Bonanno crime families. Taking the Lucchese crime family, for example, there were 2 successive groups of leaders of that family who were incarcerated for periods of time approaching life imprisonment. What they are left with in that crime family now is, I should say, a pool of diminished talent to fill the ranks up in the higher echelons of organized crime, and to carry with them the wherewithal, the knowledge, and the ability to interact on a sophisticated level. So there has been a great deal accomplished over the last 10 to 12 years in the war on organized crime in New York.
Greg, but I remember watching some movies where one organized crime figure said, we're bigger than General Motors. Is that true? Is organized crime in the United States really a multi-billion-dollar enterprise?
It is a multi-billion-dollar enterprise, but it's one that I think is shrinking. I think the strongest influence that traditional organized crime has in America is through labor racketeering, through their control of actual segments of industry by reason of their control of unions that have jurisdiction over these industries. For example, construction in New York, the labor unions involved in many aspects of construction have been heavily infiltrated and influenced by organized crime for years.
Including the United States courthouse, I understand.
Partially, I'd say. I'm somewhat familiar with that. The carting industry in New York for decades has been controlled by organized crime, and almost to the point that there's a subculture of organized crime and members of the industry that are working in it. That I think is
Ben throwing up his hands here. Do you have a comment on that, Ben?
I think there's been a terrific waste of government resources, in part over the last decade, in prosecuting organized people alleged to be involved in organized crime, almost to the exclusion of ignoring the real problems that affect the quality of life in New York. I think if half the resources that have been focused on what the government claims to be organized crime were focused on cleaning up street crime, you could walk down the streets of Manhattan at any hour of the night, there would be a police officer on every corner, and you wouldn't have your random muggings and robberies and burglaries that are really terrorizing the city.
How do you feel about that, Greg?
I couldn't disagree with it more. First of all, the amount of resources that are actually devoted to combating organized crime are minuscule in comparison to the number of members and personnel of law enforcement that are fighting.
I think it's hundreds of millions of dollars. I saw it in some of the cases I personally was involved in. I think in one of the major cases I defended.
The window case.
The Windows case, Greg prosecuted. I defended it. I mean, the Xerox costs in that case, from the government standpoint, had to be in the tens of thousands of dollars.
In that one?
My client was acquitted in that case. Other defendants were convicted in that case, and I'm not suggesting that the case was a complete waste of time. I'm not suggesting that. I am suggesting that throughout the United States and during the 70s and 80s, there was a substantial focus on organized crime. It became the darling of the Justice Department. Hundreds of millions of dollars were devoted to fighting organized crime, to infiltrating organized crime families, to doing electronic surveillance. The upshot of it is that there are 100 people in jail serving substantial prison sentences. Organized crime, if it's out there, is still out there, and the quality of life in New York has degenerated to the point where you can't walk down the street.
Ben, let me just ask a personal question. Take off your lawyer hat for just a second. You're a human being now.
Right.
Tell me what these alleged organized crime people, what are they like? Are they just like you and me? Are they like someone else?
Well, I will tell you what's of interest to me is how the government defines who is and who is not a member of organized crime. And I've cross-examined a number of people on that very issue. There are people who claim to have been involved in organized crime who've now become informants who testify regularly, and they tell the government what the inside track is. What's more significant to me is not what a member is or a member is not, but the government has targeted tens of thousands of people across the country as associates of an organized crime family, and no one has ever been able to give me a good definition of what that means, other than to say he showed up in a surveillance film next to an organized crime person, therefore he must be involved.
Greg?
Well, first of all, for Ben to suggest that hundreds of millions of dollars have been expended to the detriment of other law enforcement activities, I think is a wild overstatement. I can tell you that if you added up the number of prosecutors who worked with me for the previous 10 years and focused efforts on organized crime, you'd see there were only about 25 or 30 attorneys in the Justice Department in New York over the last 10 years or so who were dedicating themselves full-time to working on organized crime cases. And for our efforts alone, just looking at one large organized crime family, there were essentially about 6 federal prosecutors in New York and a handful of agents in one squad who were working those cases. And I think it was probably one of the most efficient uses of federal monies in law enforcement ever imaginable, if you could look at the accomplishments that the squads and the attorneys in the southern and eastern districts of New York accomplished. I'd say one other thing, that one thing organized crime does is that perhaps you don't see it on the street except to the extent that organized crime figures are shooting at each other, and occasionally a stray bullet gets someone, but there is also a lawless society which is enforced in certain sections that are run by organized crime.
But it's insignificant.
Ben, let me ask you something. Let's get back to that question I had asked before. In your experience, these people who Greg say are shooting at each other, when you have met these alleged crime figures, do you handle them differently than you handle a person who is not an alleged organized crime figure?
Well, I make it a practice of keeping an arm's length distance between all of my clients for obvious reasons, whether they're supposed to be members of organized crime or not. You have to recognize that the only thing a good criminal lawyer has really going for himself or herself, besides talent and experience, is really their credibility in the system. And if you compromise that credibility, it's a terrific disadvantage and you never get it back. So if you're asking me, do I treat those cases differently? They generally are more complicated. The personalities of the individuals involved are more complicated. In many ways, they are easier people to represent because they are used to the government hounding them. Whereas the average citizen, first time they get a subpoena, they have a stroke. Someone who's been around the block before takes it as a cost of doing business.
We have to take a break now, but right after the break, we'll talk about OJ. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us. You guys.
The air dances with the waters, which brings the rain that feeds the land, that is home to the animals. All life dances together.
In a world so connected, choosing one environmental cause can be hard. EarthShare is 40 environmental charities working together. You and your company can help by calling 1-800-MY-SHARE.
All life lives, or doesn't, together.
Excuse me, do you wear your safety belt?
Why, no, I don't wear my safety belt.
Thank you.
You could learn a lot from a dummy. Buckle your safety belt.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about the relationship between a criminal defense attorney and his client and the prosecution. Now, Greg, you were with the prosecution for many years. You were deputy chief of the racketeering of the U.S. Attorney's Office Eastern District. Now, do you have to give all your information to the defense? Do you have to give all your tapes, your videotapes, all your witnesses? Do they know your whole case before you start?
Depending upon the case, they may not know all the witnesses, but they'll have any tapes that we have, any documents that we intend to offer into evidence, any exculpatory evidence that may be known to us, any information that could be helpful to the defense to impeach our witnesses.
No surprises.
We never get all the information. We get a lot, but we never get all the information.
What don't you get?
We don't get what undermines the theory of the prosecution routinely. We generally have to dig that out ourselves. And very often what we don't get is essentially what agents or their witnesses feel that it's none of our business to get. And stuff like that generally is the difference between winning and losing.
I think the battle that goes on, I think the battle that now as a defense attorney that I think should be vigorously fought before trial is pressing the government prosecutors and pressing the district attorney's office very hard for gray area material, and I'd call it. Questionable information of a questionable stature and a prosecutor may think he could get by withholding that might not be so conspicuously helpful to the defense in impeaching a witness or in showing the innocence of a defendant, that he can, in his own mind, ethically keep that concealed.
The problem is a lot is left at the discretion of the individual prosecutor you're dealing with, and prosecutors like defense.
What about the judge? Doesn't the judge have a say in what
some judges do, some judges don't want to be involved in the process. Let the sides work it out.
Then what do you as a defense attorney have to give to the government?
Nothing.
What happens if, let's assume your client comes to you and says, you know, listen, I got this tape. The screen was going on and somebody mailed it to me. This is a tape of the crime. Do you have to give that to the government?
Chances are you do not. I mean, there may be certain ethical scenarios where I could see the answer being possibly, and in that case you might have to turn it over to the court for an in-camera inspection. For example, has the material been subpoenaed? Is your client under an obligation?
Well, let's assume it's not
to turn it
subpoenaed. The
over?
government doesn't even know about it.
Well, it depends on what the object is.
Greg?
Well, there are certain things that a defense attorney has to turn over if specific requests are made.
And no request?
Give an example. If you have an alibi defense you're planning on running with, and the government makes a request for an alibi defense, you'll have to offer evidence of that, or you're
I was nowhere near the scene.
You're going to run the risk of either being precluded from offering it, which is very unlikely, or at least a delay in the trial. Another would be an insanity defense. A third would be, there's a reciprocal discovery rule, it's called, in federal practice. Ben's very familiar with this. And in theory, a defense attorney is required to turn over to the government any evidence it intends to offer in its own defense case.
Okay.
Never happens.
We heard it here. Ben, now you just recently won a major case in Long Island where you represented, I believe it was a town official of Brookhaven,
right,
who was accused by someone who had stolen $450 million of taking bribes. He was successful in that, then he was acquitted. If you were handling the O.J. Simpson matter, you were defending O.J. He came here to New York, he hired Ben Brofman, he brought him out to California. How would you handle it?
Well, I think the defense lawyers are generally doing a very good job for the most part. I think one of the things the O.J. Simpson will demonstrate is how a battle of experts can create such confusion among the lay jurors that they may throw their hands up in the air and saying, how can we ever decide anything beyond a reasonable doubt? And one of the things that this case will turn on, recognize there is no murder weapon, there is no witness to the murder. This is going to be a case that's going to be determined in large measure by scientific evidence. And the difficulty the prosecution is going to have is that DNA evidence is based on an evolving science. And the experts today who vouch for it were the very same people who 3 years ago criticized it. And you're going to have as many experts on the defense side as you have on the prosecution side. And my feeling is that what the defense lawyers need to do is keep the jury focused on two things and two things only. One, the extraordinary popularity of O.J. Simpson, which is a tremendous boost, especially in southern Los Angeles, especially with a predominantly non-white jury. So they've done a terrific job in almost winning this case during the jury selection process. Second, keep the jury focused on the confusion among the scientists. Get up in front of them at the end of this trial and say, ladies and gentlemen, there is a reasonable doubt here, and therefore you have to acquit.
Now, Greg, I know you've successfully won many cases for the government. If you were advising Marcia Clark, what would you tell her?
Well, one thing she's got to be very concerned about is what Ben pointed out, and that has to do with the expert evidence. I think there's a real lack of understanding in the bar about the quality of DNA evidence. The DNA evidence doesn't provide the signature or fingerprint that the public expects it to. And what you're going to learn in this trial is that when the DNA comparison is done, it's not as though the scientists that are doing this technical work are able to pick up a band of DNA, this complex molecule, and pick up another band and match it and say, we have the same ones, and therefore it's the same person. Rather, it's 2 or 3 steps removed from that. It's a matter of taking DNA, mixing it up in a lot of GOP, taking an X-ray of it, and the X-ray projects what they call bands on a piece of paper, and then experts take a look at the bands and say, I think the bands are the same or they're not the same. So she's got to be very, very, very leery of relying too strongly on just the DNA evidence in that case, because you're going to hear a lot of inroads made, I think, in this trial.
And how important is the opening statement?
I think the opening statement in a trial is critical. I mean, the opening statements have been found by people who've studied this to be dispositive in almost 80% of the cases where jurors have been interviewed.
They decide the case after the opening statement and go
apparently
keep down that street?
The statistical studies have demonstrated that 70 or 80% of jurors who have heard powerful opening statements are so swayed that inevitably they end up voting for the side that has so swayed them during the opening statement. That is not to say that happens in every case, and this is not your normal case. I will tell you the issue in this case that I think the trial will ultimately turn on in my own judgment, and that is the question of race, as distasteful as that may sound. Two sides. One, police in southern Los Angeles are very suspect when it comes to issues involving black defendants because of the terrible history in the Rodney King case and a number of other cases. And second, the government comes to this case with a great deal of baggage in Detective Furman, who, as we all know by now, is someone with a checkered past who has admitted in an attempt to get the disability pension that he was in fact someone who conjured up hate among people who are of African American race, hated couples who are multiracial in nature. This is the defendant who finds the key piece of evidence. When you want to create in the minds of a juror the suggestion that evidence could be planted, you could not ask for a better messenger, if you will, to have planted the evidence than someone who in the past, in his own statement under oath, has said that he imagines arresting people who are black for crimes that they didn't commit.
Greg, do you agree?
Yeah, I think so. It's perhaps a New York point of view, but I'd say only in California could the lead investigator who found one of the critical pieces of evidence have a history that he has, and that's going to be fully exploited.
So if I understand what Ben is saying, the die has been cast. No matter what happens, the jury may very well break down along racial lines and vote that way.
But they also have, the defense has an enormous problem in terms of the motive evidence that's going to be admitted at this trial. There's a history of O.J. dealing with his spouse in their altercations, the taped evidence regarding that, which is going to cast a shadow over
How would you
O.J.
handle that, Ben?
It's not a slam dunk for either side, and I think one of the things the defense is going to have to do is they're going to have to deal with that head on, and perhaps confront it and take it on the chin, saying, look, it wasn't a perfect marriage, but for 15 years they argued he didn't kill her, and to the extent that domestic violence on occasion may lead to something more severe, it happens so rarely that suggests O.J. Simpson, who we all love and have grown to admire, would do this, is preposterous.
Can you explain to us how they're getting in all these prior acts, not to show propensity, but to show, was it modus operandi?
Motive and intent. There is an exception to the rule that allows in evidence of prior bad acts in a murder case, for example, if the question of intent, motive, is not being conceded. I personally think that it was a very close call. I think that Judge Ito was on the horns of a dilemma, and I think, quite frankly, he split the baby here. He gave the defense the racial material on Furman's past, and he gave the prosecution the prior bad acts of O.J. Simpson.
But Greg, let's talk on a practical level. I'm a juror there. I know the judge told me I am not supposed to take all these prior acts for propensity, that he did this crime because he did all the other crimes. But I heard it. As a practical matter, how do you feel about it?
I think it's very, very difficult for the jurors to resist it. Even if they could resist the impulse that they'd otherwise have, subconsciously or subliminally, it's going to have an effect on them. It's certainly going to strongly affect their view of O.J. They can try, if they're honest, good person sitting on that jury, to follow the rules of the judge, but that evidence is potent.
Now, I read something that they believe that the conflict that we read in the newspapers between the attorneys, F. Lee Bailey and Shapiro, that was made up to gather sympathy. You have any opinion on that?
I don't agree at all. I think it's something that happened. I think it was unfortunate. I think they're both embarrassed by it. But as I said just the other day, I believe that they are both sufficiently professionally experienced in high-profile cases to put this behind them. They may never like each other again, but I think what they're going to do is they're going to put that aside and try and do what's in the best interest of O.J. Simpson. And what's in the best interest of O.J. Simpson is having the person with the most courtroom experience conduct the major and most significant portions of that trial. And it's not Robert Shapiro.
Greg, not Robert Shapiro. Greg, bottom line, what do you think is going to happen?
I think there's going to be a hung jury.
Hung jury.
Everybody says hung jury. What do you say? This is Alan Schnorman. You're watching Lawline. Come back next week and we'll find out.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.